Good morning, everybody. My name is Pranav, a legal intern at Lexis and Company for the month of June. And today, I will be talking about the controversy surrounding the payment of school fees amid the COVID-19 pandemic. The COVID-19 pandemic has brought with it significant economic ramifications across sectors owing to the lockdown imposed over the past 15 months. And the education sector is no such exception, with students having no option but to make arrangements to attend online classes as schools remain shut. Amidst all this, educational institutions continue to charge an exorbitant school fees without any relaxation. In fact, some schools went on to hike their fees, putting parents across the country in a tough spot. Inevitably, the courts in India saw a huge surge in litigation on the issue of payment on school fees. The brick and mortar model of schools underwent a complete reform and shifted to digital modes to conduct classes. This consequently led to parents of school children questioning several heads under which fees were charged, such as unused facilities, including meals, travel charges, and a host of others. Several state governments released circulars, notifications, and regulations announcing relaxation in school fees. However, the haphazard manner in which this was done sparked confusion amongst the parents of school-going fees. The story thus far: the stance of state governments and the courts. In early days after the nationwide lockdown was declared and after schools began in conducting online classes, several state governments, including those of Punjab, Haryana, Rajasthan, and Uttar Pradesh, announced relaxation in school fees. But still, parents of students continue to receive fee statements from school despite such government orders. They also faced many instances of harassment as school enforced payment of increased fees amid the pandemic. This encouraged parents from Rajasthan, Orissa, Punjab, Gujarat, Haryana, Uttarakhand, Delhi, and Maharashtra to move to the Supreme Court for a moratorium or of deferment on the payment of school fees till the lockdown persisted. The plea filed by these parents also sought directions from the central and state government to aided and unaided private schools to only charge proportionate fees based on the actual expenditure incurred by the schools. This was also a time when some states like Karnataka and Madhya Pradesh imposed a ban on online mode of classes owing to the harmful effects of screen exposure from children till grade 5. For students from grade 6 to 8, the state governments put a 2-hour cap on classes a day, with each class not exceeding 30 to 45 minutes. However, the Apex Court declined the plea, holding that these matters ought to be dealt with by the respective high courts, as the challenges faced in each state may vary from one another. This in turn led to a plethora of litigation in high courts across the nation. In April 2020, the Tamil Nadu government issued a notification barring forcible payment of school fees during COVID-19. The Madras High Court directed that a scheme be formulated for the payment of school fees in installments so as to balance the interest of schools and aggrieved parents amid the pandemic. It reiterated that the notification by the Tamil Nadu government only barred forcible payments and did not stop parents from voluntarily paying the fees. In response to this, the government proposed a scheme for payment of 75% of the tuition fee in 3 installments, 25% in each installment, and permitted the remaining to be paid once the schools are open. In a case filed by private institutions against the government order, the court allowed private institutions to collect 40% of tuition fees as advance and the remaining to be paid in the following 2 months. All of this must be in accordance with the fee collected in the previous academic year of 2019-20. The court warned the private institutions that they would be charged for contempt if they insisted on full payment of fee during COVID-19. In November 2020, the High Court allowed a further 35% of fee to be collected in addition to the earlier directed 40% to all private unaided schools in order to meet the expenses of the institutions. Last year, the Gujarat government released a circular which completely barred the collection of tuition fees during COVID-19. The Gujarat High Court, however, quashed the circular and ordered the state government to consult with the unaided private school representatives to arrive at an amicable solution. When the negotiations between the parties fell through, the court refused to intervene and said that the government can take an independent decision under the Disaster Management Act and the Epidemic Diseases Act, which were in force owing to the pandemic. Ultimately, the State Education Department issued a notification allowing a 25% reduction in school fees and barred collection of miscellaneous fees in the name of activity fees, transport charges, etc. The notification also advised parents to pay pending fees from the previous academic year and 50% of fees for the next 2 quarters by the end of October 2020. In West Bengal, despite directing that students need to pay only 80% of the fees, some schools continue to enforce a 100% payment. The Calcutta High Court did not allow any further concessions but granted an increased time window for the parents to pay any fees. It was also emphasized that no coercive action must be taken against students who have not paid the fees. Additionally, the court ordered the setting up of a committee to address the grievances and examine the school accounts and the fees charged in each private unaided school. In response to this order, an association of 145 schools filed a plea before the Supreme Court which stayed the setting up of the committee. The Kerala High Court issued a similar direction in a case filed before it to not expel students due to the non-payment of fees. The Kerala government then issued a directive in December 2020 requiring all schools in state to not charge fees in excess of expenditure. This decision was prompted by a school charging an exorbitant celebration and miscellaneous fee amid the pandemic. A full bench of the Kerala State Commission for Protection of Child Rights asked schools for a 25% reduction in the existing fee. This is applicable to the CBSE and ICC schools as well. In June 2020, the Punjab and Haryana High Court restrained schools from charging transportation fees and maintenance charges as students were studying online. It ordered that only 50% of the maintenance fees were to be paid and to ensure the upkeep of school premises during the pandemic. It held that schools can charge fees regardless of whether or not online classes were being conducted. On October 1, 2020, the High Court set aside its previous order and ruled that schools can charge tuition fees only if online classes were conducted regularly. It also directed school managements to file their balance sheets for pending 7 months. In Karnataka, 2 circulars issued in April 2020 restricted school management from collecting fees during the pandemic, though the circulars permitted payment of current academic fees in installments. Due to the absence of a deadline to that effect, only 1 to 2% of parents paid the fees. The circulars were also silent on the unpaid fees from the previous academic years. Due to the lopsided nature of the circulars, the same were challenged before the Karnataka High Court, which issued notice to the state and granted interim relief of paying 50% of the education fee for the upcoming academic year after clearing the dues from the previous year. In similar vein, 2 circulars were issued by the Rajasthan government, one restricting private schools from collecting fees for 3 months and the other extending the duration of the first circular until further orders. As an interim measure, the Rajasthan High Court ordered 70% of the tuition fees to be paid, but later stayed this order and directed that no course of action must be taken against students facing difficulty in paying fees. Ultimately, the matter found its way to the Supreme Court, which allowed 100% collection of fees through 6 installments from the students of private unaided schools in Rajasthan, beginning from March 5th of 2021 and ending on August 5th of 2021. However, in case of any difficulties faced by parents, the court held that they could approach the school authorities who would consider individual cases and deal with them sympathetically. In May of 2021, the Apex Court allowed private schools in Rajasthan to collect 85% fees for the year of 2020-21. The 15% deduction was granted in view of the unused facilities by students in 2020-2021. It was directed that the students have to pay the fees by August 5th of 2021. The Maharashtra government came up with the regulation on May 8, 2020, directing schools to not hike fees during the academic year of 2020-21 on the account of the pandemic. After the same came under the challenge, the Bombay High Court imposed a stay on the directive in June 2020 by questioning the jurisdiction of the government to interfere in regulation of school fees of private unaided schools. In March 2021, the court vacated the stay on the directive and directed that no student shall be debarred from attending classes or attempting examinations owing to the difficulty faced in paying the increased component of fees. The court also clarified that the directive cannot be construed for refunding any fees during the pandemic year of 2020-21. The most recent case was before a high court. A public interest litigation was filed for a 50% reduction in school fees on the same lines as the case discussed above. It was contended that fees demanded for the facilities not used by students would be considered as profiteering. Now the question arises is, can schools arbitrarily raise their school fees? And what recourse do parents have? The subject of education falls under the concurrent list under the 7th schedule of the Constitution. This means that both the state and center have authority to regulate matters that fall within the ambit of education. In view of fee hikes by several private unaided schools, It is to question whether the schools can arbitrarily hike the fees and what parents of school-going children can do in this regard. The Supreme Court in TMA Pai Foundation v. State of Karnataka considered the issue of regulating fees by private unaided schools. It held that states should devise a machinery to ensure that there is no profiteering from the fees collected, but a reasonable surplus to further education is allowed. In Islamic Academy of Education v. State of Karnataka, while considering what constitutes reasonable surplus, the court held that every institute can fix its own fee structure to meet the expenditure to run its institution smoothly. This stance was reaffirmed in the case of P.A. Inamdar v. State of Maharashtra, in which the court allowed private schools to devise their own fee structure, which can be regulated by the state to prevent profiteering. This led to the introduction of state-specific fee regulation legislation. For example, in Maharashtra, the Maharashtra Education Institutions Regulation of Fee Act 2011 and the Amendment Act of 2018 mandate a parent-teacher association, executive committee and divisional fee regulation committee to ensure proper management and revision and regulation of school fees. When increasing school fees, the school management must submit the details of the executive committee at least 6 months before the next academic year. While giving its approval, the executive committee has the authority to decide the fee afresh and convey the same within a period of 30 days from receipt of details of fee proposed by school management. In February 2021, the Maharashtra Minister of State for Education called for an action to be taken against schools that are hiking fees and violating state regulations on education. Recently, the State Education Department sought suggestions to amend the Maharashtra Educational Institution Regulation of Fee Amendment Act of 2018. In 2017, the state government had amended the act allowing private schools to hike fees 15% every 2 years. Since then, the act has been used by private schools to hike fees exponentially. What are the students' rights to education and the school's right to collect fees? Finding equilibrium at this juncture, it is pertinent to weigh the conflicting yet mutually intertwined interests of students and school managements in order to ensure equilibrium. Especially at a time like this, it is important to find middle ground between students having to pay exorbitant fees and school administrations being able to function smoothly without disturbing payments to staff and upkeep of premises during the lockdown. While schools continue to incur costs in all form of staff salaries, etc., even as they remain physically shut, there is also a significant expenditure incurred by the parents. The DFRC, which is a key fee regulating authority across states, has no penal powers and little grievance redressal authority, making it difficult to hold private unaided schools accountable for their arbitrary acts. It is also crucial for an external authority to intermittently overlook the overground functioning of the provisions laid down in the state laws. Additionally, just like the Maharashtra government invited suggestion on changes to the law and regulation of school fees, other state governments must follow suit and invite suggestion from affected parents. Only an effective grievance redressal policy coupled with a mechanism to implement the same can enable stakeholders to reap the benefits of the law. And with this, I come to the end for today's discussion. Thank you.